because you've got new bundles, there's no guarantee, of course, that new ones will work either. But you
Well,
have a
I've got
better
a
chance
as well, so belt and braces.
We're very grateful. Thank you so much.
So, my Lord and my ladies, the fourth submission I was going to make in relation to the factual matrix on the issue of ground 2 was that the claimant was, as the defendant would have known and understood, an inexperienced litigant. And I don't take it to be in issue that the claimant was inexperienced, or that the defendant would have appreciated or expected her to have been inexperienced, because fortunately most of us may be involved in either no accident or possibly one accident, but apart from a small cadre of claimants familiar to some of the courts who are repeat business, it's not something that's expected. And the significance of this, in our respectful submission, was underplayed somewhat by the judge. As to the significance, see first of all the Carradine case, and that's Authorities Bundle 1, tab 7, page 162. And what there is, and this passage was quoted by the learned judge, but I'm taking you to the judgment itself. It's the judgment of Lord Justice Donaldson. It's in relation to the scope of duty of a solicitor under a retainer. But you can see the passage which we've sidebarred. If I pick it up in the middle, if he finds unusual covenants or planning restrictions, it may indeed be his duty to warn of the risks and dangers of buying the house at all, notwithstanding the client has made up his mind and is not seeking advice about that. I say only that this may be his duty, because the precise scope of that duty will depend inter alia upon the extent to which the client appears to need advice. An inexperienced client will need and be entitled to expect the solicitor to take a much broader view of the scope of his retainer and of his duties than will be the case with an inexperienced client. It's this reasonably incidental to concept that is elastic or flexible and very sensitive to the facts. And if you have an inexperienced client in that case, or potential client or customer, I think it's being referred to in our case, then you do have to take a broader view by reference, amongst other things, taking into account the inexperience of the customer to their need for advice, lest they fall into the trap, if you like, that otherwise they're exposed to. And that case was referenced by the learned judge in his judgment, page 143. Page 143 is where he finishes up, so it's actually page 142 that he sets out the same passage, paragraph 127. And you'll see he then continues. So I'm on page 142, my lord.
Yes, thank you.
Para 127, after the quote, it already starts with but, in terms of let's distinguish this. And then it ends with, again, another but over the page, but that does not take the matter much further. But it does, because it's really important to understand that you're dealing with an inexperienced client when you address the scope of a duty of care, which does exist, my ground 1 point. And then can I take you to a case called Minkin and Landsberg? So that's Authority Bundle 2, tab 38, I think it is. No, 38. Thank you. 22, sorry. Tab 22, and it's page 510. And it's the guidance given by Lord Justice Jackson at paragraph 38. Again, we're talking about a solicitor-client relationship. And you can see from 1 and 2 comes in, tackles this proffered advice, which is reasonably incidental to work that he or she is carrying out. And then in determining what advice is reasonably incidental, it's necessary to have regard to all the circumstances of the case, including the character and experience of the client. And then at little 4, Lord Justice Jackson gives what he considers to be a fairly bland illustration. In his last illustration, an inexperienced client will expect to be warned of risks which are or should be apparent to the solicitor but not to the client. Now, I can't run with that all the way to like full legal advice because all of the legal advice is apparent to the solicitor and not the client. I understand that, everything's got to be read in its proper context, but one can see what Lord Justice Jackson is pointing towards because he's talking about the context of reasonably incidental to.
He's talking about the context where there is in fact a formal retainer between solicitor and client.
Absolutely, my lady, and I recognise that fully. But the idea that that isn't a relevant consideration because there isn't a retainer is not an acceptable one, because we already have here a duty of care in relation to the limitation issue. We do have a duty of care. I've already made my submission in relation to the Spire case. Is it a case where I can just say, there's an assumption of responsibility in relation to limitation period, all I need is reasonably incidental, beg, borrowing and stealing all of the case law from retainers? And I've already made my submission. I don't think that's accurate. I think the right way to look at it is still to look at it as an assumption of responsibility in relation to what I say is the relevant duty in this case. But I do say that one absolutely learns from this because the same underlying principle is in play. That is how I put it. It's a bit windy to say it like that, but that I think is the right way to say it. That's why early on I made my submission under ground 2 saying you can say it, call it reasonably incidental to, and either way, an inexperienced customer is understood as such to be an inexperienced customer is a really important part of what we're looking at. Here we've got an inexperienced claimant who has not notified or not taken steps to alert the tour operator so as to notify its insurer, but who's phoned the legal helpline from her hospital bed 6 days, I think, after the accident.
Solicitor doesn't know whether she's notified or not.
No, my lady, that's part of what I sought to cover at the early point. If you want to ask and address the issue, it's on your pro forma that Ms. Strutt says normally has gone through. You choose not to ask, you simply say, I'll give advice which is partial. I don't mean that too harshly, but it's partial advice. I won't even ask that question. It is critical in this case, and I'll leave it be. And what that does is it sets the claimant off on a course of understanding that there are no other steps she needs to take promptly. And it's a really simple step as well. This advice can be given in a matter of moments. It's short, it's simple, it's not expensive. It's just clean advice in relation to an issue that is front and centre for the defendant, in which clearly we have reliance. And I've covered the parts of the judgment. I mean, of course there's reliance, because that's what's happening. You've got someone contacting a legal helpline.
Well, we're covering old ground now, aren't we?
Exactly. Well, that's the
I
risk.
think we really do have the point that this is somebody who's phoned a legal advice helpline and has received at least some advice on legal matters, as is recorded, and they were entitled to rely on that. That's not disputed either.
Exactly. And I've addressed
the question. The sole question in this case, as I see it,
yes,
is does that process involve a duty on the solicitor or the person manning the helpline to advise about the need to immediately notify the tour company?
Absolutely.
That's it, isn't it?
Absolutely. That's how I sought to frame it at the beginning, saying there are 2 issues. That's the first issue, and I'm not going to succumb to the temptation now to rehearse the submissions I've made.
We really do have it, and we also have the point that your submission that relevant to that issue is the fact that, like most people who phone a legal advice helpline, they are not experienced litigators.
And as ever, the only thing I would say is it's the cumulative effect or the combination of all of the factors. One can't strip a factor down and say, well, you have to look at the package.
Yes.
Can I then move to ground 3? Ground 3 in substance is, was there at the least a real prospect that HCC would have responded to the claim following the administration of low cost? That's the issue, in my respectful submission. So the key question is what would have happened, not how does the excess clause apply? And on this issue, the court should lean in favour of the claimant, since the issue arises on the counterfactual basis. As a result, we're now assuming in the claimant's favour that we've won on the issue of ambit of duty care. Clearly there was a breach, that follows. If the duty of care encompasses this need to advise, there was no such advice given. So we're now in a world looking at causation where we've established our breach of duty.
Well, doesn't it turn on whether the insurers would have taken the point that that irrespective of the notification provisions, the access provisions meant that they weren't on the hook?
Well, lady, it comes in 3 parts, I think. But just before I include it, absolutely, that's right. But just before we get to that, in terms of at each stage of the analysis, because we are looking on a counterfactual basis of that which did not happen as a result of the defendant's breach of duty, the court is required to lean in favour of the claimant. And we can see this from a variety of places, but including Phillips and Watley, which is an authority bundle 2, tab 18, Privy Council case at page 431, paragraph 45. I think this is Lord Nance. Lord Mance delivering the opinion of Privy Council. Page 431. Thirdly, it's appropriate to record that the board considers that both the judge and all the members of the court were correct to identify the relevance of the principle of in Armorian Delamere. And Armorian Delamere is a case in which I can immediately acknowledge the court is well familiar. So that's this leaning in favour business. To the second issue, as to other aspects of the case. And that was a notification case, but it doesn't matter whether a notification or excess clause. It doesn't matter if we're dealing with the classic prospects of success, because the Armoury and Delamere is referred to in the Mount and Austin case, which is in the bundle, but I don't need to take you to it, because it applies across the board when you're looking at the counterfactual position, because you never got that far. You didn't run your case to see if it was a good case. You didn't test the insurer to see if they would take the point on notification. You didn't test them to see if they take the point on the excess.
The facts of Armoury and Delamere are very different now, aren't they? Very, very different.
That's as I understand it, the jewellery which has been stolen, and the plaintiff doesn't know the value, and of course it's been taken by the defendant who prevents him from knowing its value, and so the court says treat it as super expensive.
Yes.
But it's the same principle. It's a little bit like Drake and Harbour principle in Drake and Harbour on causation.
Yeah.
It's a theme which I've submitted.
Yes.
Before is actually underlying it simply the principle of fairness.
Yes.
It's an issue of fairness.
Yes.
That's what lies at heart of that, as per adverse inferences and all the rest. It's just an issue of fairness.
Yes.
So, but that's an important point to have always in mind before saying, well, the judge was entitled to, and the judge did close you down in the way that he did. So be it.
Yes.
The 3 issues which in our submission is here for the court to consider. First, was the judge right to find that it was, his words, highly likely that HCC would have refused to indemnify low cost? Secondly, even if that is right, does that mean that the claimant is still entitled to recover for the chance, albeit low, that HCC would not have refused to indemnify low costs? That's our supplemental skeleton point. And thirdly, in any event, if HCC had refused to indemnify low cost, would what is the effect of that going forwards? If to a trial, the question would be, would HCC have been bound to succeed? Because it's no good them saying they'd have taken the point if the point was a bad one. And if they'd have insisted on a trial, then this court has to look at the trial of that issue.
I think it's implicit in what you just said. And forgive me, this is a question from ignorance. As I understand it, you're saying it's no part of this process to decide whether, as a legal matter, the policy was required to respond in this situation.
I'm not saying it's no part, my lady. I'm saying that.
But where does it come in?
In my third one, if in any event, so if it's something, a point that the HCC would have taken.
Yes.
If they wouldn't have taken it, we don't get there. We've got that secondary point about looking at the judge. We still win, but albeit for less damages.
Yes.
Then we've got the if they had refused to indemnify low cost, that leads to two outcomes: either later settlement or later trial. And to that end, this was an answer I sought to make to an observation from Lady Justice Andrews right at the beginning, in terms of, is it just an issue of fact, or is it, as I was submitting it, mixed fact and law at this stage? Because the court would have to look at the term and make its own assessment today as to whether the judge was right to essentially say, and you're bound to lose. It was hopeless.
But you put it in that. Sorry, you put it in that way, bound to lose, rather than.
Yes. So it's the difference between the two is is thin, but I think that is the right. I would submit that is the right way to look at it. You're ultimately looking at a question: would we have recovered money from the insurer? And part of this is a very core part of the submission I'm going to make, which is that you don't address that by simply saying, "Oh, looking at the legal merits of the point, it's a bad point for the claimant and a good point for the insurer."
It's a good starting point, though, isn't it?
Of course, it's relevant, my lord, but it's almost all cases in which it can subsequently be established that one party was right and the other party was wrong don't get to court.
But we also have some evidence as to what actually happened in the present case and what HCC's attitude was. They took a "we're not responsible" argument in relation to a different clause. What then happened is that Irwin Mitchell perfectly responsibly went to counsel, who gave some advice on the chances of getting around that. And it was decided to drop the claim. Now, surely, if you're looking at the counterfactual, exactly the same thing would have happened. You would have had the insurers saying, we're not on the hook for this because you haven't exhausted the excess. Irwin Mitchell would have gone to counsel, who would no doubt specialist counsel on this point, and they would have received some advice.
No, my lady.
So why do you assume that you'd go to trial?
The position, I don't assume we would have gone to trial. But the position is materially different, because what would have happened on this counterfactual is we would have notified the insurer, or the tour operator, which would have notified the insurer, and then the case would proceed. There would be investment by all parties in the process, and you then...
Necessarily. I'm sorry to interrupt you, but
Yes,
not
ma'am.
necessarily. If the excess clause operates in the way in which the judge seemed to think that it did, the insurers don't even, well, the insurers undoubtedly don't have to put their hands in their pockets for defence costs at all, anyway, under the insurance. But if it operates in the way that is suggested, they are not on the hook at all until it can be shown, demonstrated, that £560,000 worth of claim has been absorbed, whether you say it's liability, which is your case, or whether it's paid, which is another case. So they're going to sit back and say, we're not getting out of bed for this one because only 5,600 has been exhausted. Whether it's liability, whether it's paid, whether it means paid as in shelled out,
Yes,
or whether it means we're on the hook for 5,600.
Yes, my lady.
Unless there's some evidence that suggests that they were looking at it from your perspective as favourably as possible, that they already had other claims out there for which they were prospectively liable, that exhausted the excess, the annual excess, insurer is going to say, "Oh, sorry, it's your problem, not ours."
Well, lady, that in our respectful submission is pretty much the level opposite of leaning in favour of the claimant when determining an issue. That is just simply leaning in favour of an insurer, which can be heard to say, "Oh, well, I don't think I would have paid that money." But
No,
what we've got is a reality. The commercial reality is it is not attractive for insurers not to pay out, let a case proceed, and then want to take a point which can then be litigated.
Well, maybe it isn't, but we've got a fact finding by the judge saying it, I consider it highly likely that at any given time HCC would have taken the point attractive or not. And so they would have taken the point. He's got expert evidence that backs him, so he's got evidence on which he's entitled to make that fact finding. Where do you go from
And
there?
then he's got very thin evidence. What he's got is the market had hardened. Okay, the market had hardened. Where does that take matters? We're in real terms. Insurers will try to settle a case. Notification is one thing. They can say this is a precursor to coverage. That's a separate thing. That is just they looked at the notification point. They say they were prejudiced. This is just can I get out? Can I get out? Am I right to think I can just get out?
No, it's not an exemption clause. It is a precursor to cover.
Well, it's a precondition to indemnity, my lady. Yes, but it's not like the notification. It's just if it's a precondition, it's a precondition. It's not a prejudice doesn't attach to it. It's just a precondition. Whereas notification, as we've seen the evidence in relation to, is one in which an assessment has to be made. And this is a case in which, in the real world, whatever else is said, and not least when you lean in favour of a claimant, what you have is an insurer who would not want to risk taking this to a trial on the issue of the excess point at all, because
What's the
cases.
basis on which we can possibly make that finding?
Because you're leaning in favour, and because cases settle. That's what they do. Insurers have points they can take, and yet cases settle, or we would be in court all the time, every time. It just doesn't happen that way.
Well, it seems to me that whilst I understand the point you're making, that can we just get some grounding here?
Yes,
Obviously, all of this depends, in the first instance, on the clause. On the clause.
My lord, I'm happy to go to the clause.
So, shall we look at that?
Yes, of course, my lord. Yes. If we look at the clause, so we can actually look at the clause. That's at SB, so Supplementary Bundle, tab 13, page 82. And under General Condition 4 at the top hole punch. It's small, but you should be able to read it. That's the term, my lord. It's an issue in this case. And I'm going to seek to address it in terms of that clause in the following way. The parties to the insurance contract are at liberty to agree a pay to be paid clause. That is to make payment by the insured a precondition of indemnity. And
No, concentrating on what you're saying.
Sorry. And in the P&I context, this makes sense for at least two reasons. And can I take you now to the Firma case? Because the Firma case is the sort of source, if you like, of the judge's analysis that this is really no different from the Firma case. The words are clear, you're held to them. So the Firma case is Authority Bundle 1, tab 9. The clause can be seen in the head note at page 170. So we're in tab 9, first page, page 170, please. Down at the bottom, right at H, the court can see protect and indemnify members in respect of losses which they, as owners of the entered vehicle, shall have become liable to pay and shall have in fact paid. So that's the relevant term. And the importance of understanding the P&I context is a submission which was made by to counsel. And can I take you to the first one of those? It's at page 202, H. And right at the bottom, Mr. Sumption gave a more elaborate and more formidable argument. Surprise. And you'll see, little one, the purpose of the condition of prior payment was to prevent a member from making a profit from his insurance cover by receiving payment from the club but failing to pay the third party. And to give that its context, just look at the second one, which is 205E, when Mr. Boyd makes what Lord Gough describes as a rather different reason for that given by Mr. Sumption. And at E, he, Mr. Boyd, suggested that in a mutual insurance association such as a P&I club, it's essential that members should be able to assume the financial probity of other members because all of them are insurers as well as the insured. So if you're going to tap into a fund which you partly supporting, but you can't be bothered to pay yourself, your colleagues will be very upset. I mean, that's my terrible shorthand for two more sophisticated arguments which are being promoted. So I rely obviously on what's put in writing rather than what I've said, but that's, as I understand, that's the thrust of it. So you're dealing with a sort of a very much a sui generis or super specific scenario in which Lord Gough, as it would appear slightly grudgingly at G, says it's not inconceivable that both reasons are correct. Which I actually take to mean he was impressed by them as opposed to not. So out of the P&I context, it makes no commercial sense at all, and the courts have deliberately set their face against interpreting a clause using words such as shall pay to set a precondition. And to support that overarching submission, I've got three cases to go to and then column vote. So the first case is Charter Reinsurance and Fagan, and you'll find that at the end of Authorities Bundle 1, tab 10. And the law reports have generously included all judgments from Justice Mance onwards, but we can leap to the judgments. I beg your pardon, lady.
Tab 13.
Oh, I apologise, tab 13, not tab 10.
Fagan, yeah.
So it starts at page 262. The clause, you can see at page 331H, 331H. And that's the net loss shall mean the sum actually paid by the reinsured in settlement of losses or liability. And the approach of the House of Lords is notable. See the speeches of Lord Mustell and Lord Hoffman. So Lord Mustell, page 335. And really you could pick it up at D, but it's the important part comes between E and F. When he says, equally I'm now satisfied, the purpose of the sum actually paid in clause 2C is not to impose an additional condition precedent in relation to disbursements of funds, but to emphasise that it's the ultimate outcome of the net loss calculation which determines the final liability of the syndicates under this policy. In this context, actually means in the event when finally ascertained, and paid means exposed to liability as a result of loss insured under clause 1. See the observations of my Lady Lord and Justice Andrews earlier. So we don't even have an actually, which is far harder to get through. Actually paid sounds more like you have to pay money over than paid, or pay. And similarly, if you go to page 340, Lord Hoffman, very open in the way he approaches matters at the sidebar passage. So page 340, take for example the word pay. In many contexts it will mean that money has changed hands. usually in discharge of some liability. In other contexts, it will mean only a liability was incurred without necessarily have been discharged. And he gives an example below. And then he says what's true of ordinary speech is also true of reinsurance. And can I invite you to read the rest of that paragraph to G? So undoubtedly you can read pay to mean money transferred, but you don't have to, and the courts don't want to. And we're going to see that again in Teal, which
It all
is...
depends on the context of the insurance policy that you're looking at. That's very clear from Charter Reinsurance, because Lord Mustard made it very clear that if he'd been left to his own devices without looking at the context, he would have decided the case differently.
Absolutely, and the context that's so important is you've got the mutual P&I situation, which is a very specific situation, and I'm going to take you in a moment to the Collinvo, which says outside of that, it would appear that we are not in a world where these are treated as preconditions, and for good reason, because it strips down the effect of an indemnity, which is so that the insured doesn't have to become insolvent by meeting the excess first. It's described in the case I'm going to take you to as effectively inimicable to the point of having the insurance. So there are very powerful factors in play. And can I start that process by going to the Teal case? It's Authority Bundle 2, tab 20, it starts at page 469. This is this Tower case, Tower of Insurance.
I'm sorry, can you give me the page again?
Of course, my lord. It starts at page 469.
Yes.
It's at tab 20. And I'm going to leap straight into the judgment of Lord Mance, page 481.
Yes.
Paragraph 21, sidebarred by both legal teams. And I should give you the clause. Para 20 says BV to have paid the amount of the deductible prior to the company indemnifying the insured under the terms and conditions of this policy. And 21, he says it's not certain the word paid here means dispersed, as was held in the Fagan case, under a differently worded excess of loss reinsurance referring to the sum actually paid. So here the word paid should, in my opinion, probably be understood as being used only as a measure of liability incurred, rather than with the intention of insisting on monetary disbursement. Otherwise, the present liability insurance would not meet the aim of providing the insured with an indemnity to avoid insolvency, which third-party claims might otherwise threaten. So that's the sort of underlying premise of why it is that we have these two cases in which they walk away from language that, outside of the legal context, people may choose to think pay means transfer money, but it all depends on its context. And then the case of Lambert Leasing and QBE, because it's sets out very nicely this point, and it's then referenced in Collinvo, as I'll show you in a moment. This is a case of the New South Wales Supreme Court. It's the next tab. So in Authority Bundle 2, tab 21 starts at page 485. 485. At 487, you get the clause down at the bottom, paragraph 3, last line. Hope I'm not going too fast. And 487. In respect of all sums which the insured shall become legally liable to pay and shall pay. So you can have legal liability being expressly set out and something additional saying and shall pay as compensatory damages. But this was interpreted by the Court in New South Wales not to require a preconditioned indemnity by way of the transfer of monies. And the analysis for that starts at 494 at paragraph 15. I'm going to invite the court, if I may, to read paras 15 and 16, and then in due course perhaps to sort of scan read their way through before picking up at 21 again. So it's really para 15 to 21 with an emphasis on the sidebarred passages. The court will kind of just have a look at those.
Yes, thank you.
So the terms shall pay are not the clearest of language. That's where we get to. The judge was entirely on the other side, just saying this is the words. Look at Fagan. That's it, and it's simply not the position. So finally, I need to go to Collinvo and Merkin's insurance law. So I'm now in bundle 3, authorities bundle 3. I'm in tab 34, just dealing with a collapse in my own bundle.
Yes.
Okay. So it's page 759, and it's footnote 2, which you can see flows from between the two hole punches when the authors say some reinsurance agreements contain similar pay-to-be-paid provisions, although these have been construed as requiring payment by the reinsurers once the reinsured has established and quantified its liability to the assured. Footnote 2 includes a list of cases including Fagan and Teal, and then follows it up with, it would seem that P&I Club principle set out in the Fanti represents the exception, and that pay-to-be-paid clauses is to be given effect only in the case of mutual insurance. That was the view taken by Green J in the case that I've taken you to of Lambert, and he references the description there that it's inimical to insurance. So wholly contrary with respect to the judge, wholly contrary to the position adopted by the judge. The courts have consistently now set their face against so construing these sorts of terms, and there's nothing special about this one as setting a precondition to indemnity.
Precondition of payment, of actual payment for indemnity.
Yes, sorry, it's as setting by way of precondition actual transfer of funds.
Yeah.
Yes, well, absolutely.
But even if you're right, and I think your best case is the penultimate one that you cited, which was a professional liability insurance case, so that's the closest that one gets to the situation. How does one go about showing that the upper limits of the excess has been exhausted? In other words, how in practical terms you say that the it is demonstrated that the insurer is on the hook because there is established liability already to pay 560,000 over and above all the 10,000 claims.
My lady, just before you even get into that, I don't say it's as structured as that, because actually the question is, would HCC have paid? And it may be that there would be early doors on the quantum evaluation, and HCC say, well, put this case to bed, here's a certain sum of money. And they could even do that if they considered it was below the excess.
Well,
Because
that's
there's
speculation.
It's not speculation, lady, it's leaning in favour of the claimant.
I think they were moving back again
Sorry.
away from construing the clause.
Well,
And I think
yes, I was invited to address that issue, but in relation to the clause
I think-
itself, my lord. Sorry, Lord.
I understood. I think what Lady Justice Andrews was asking is in relation to the clause, until such time as the insured has paid and exhausted the excess. And you've shown us authorities, I think, which show that paid means there has to be a liability. So what does that entail as a matter of construction as to what the insured must show in relation to liability before they can show that they've exhausted the excess?
I've read somewhere in my readings for this case that the issues of settlement of cases sort of doesn't sit neatly with this, but it's completely understood because it happens every day. You don't have to actually establish the liability by way of a trial. You have a shows in action against you, which is deemed to be of a certain value. Once it's, and it doesn't, as I say, actually even have to be shown to be a value in excess of the excess for this to work.
Just for the sake of argument, you mentioned 1.5 million.
Yes, my lady.
let's just assume, does it go like this? Insurance company might think, ignoring the excess, at trial, this individual might succeed in getting damages of 2 million. We wouldn't be on the hook for the first 500,000,
and whatever it is.
If the insured was still around, we would potentially be on the hook for the balance. And then we'll do some calculations to work out what we should offer by way of settlement. Is that how you...
That's the real world proper analysis, answering the question, would we have recovered funds from HCC, as opposed to starting at the wrong end of the telescope, which is say, what is the meaning of the excess clause? Because you can have a meaning that is absolutely bland or obvious. Surely it's not bland or obvious that it's against us. In our respectful submission, it's crystal clear from the force of the authorities and the leading textbook in the area that I've taken you that it's exactly the opposite way. But in any event, what you have is an insurer facing a claim, an ongoing claim, who is going to be realistic. And how do we know this, and how does the court lean in favour of finding this? Because it happens all the time.
Well, I think really what it comes down to is this: is what you're saying is that if the claimant brought a claim for where the damages were going to be in excess of $1 million, the insurer would not decline coverage on the basis of an excess clause of 560,000.
It doesn't. I don't even have to go that far. That is my case because I've made clear as to why the excess clause doesn't bite. But it doesn't even have to go that far, because even if the insurer thought there is a chance I can get off on the excess clause, it's just a different question. It is, is this because we're now in professional negligence, so I'm loss of chance city? In which that's what the court is doing, leaning in favour of the claimant.
We're talking about stages here, aren't we?
We are, madam.
And I understand your ultimate argument is that you had a chance. But if I understand the whole of this counterfactual is based on the assumption, the counterfactual, that had you been properly advised on the phone call on the 19th of May, you would have notified the tour company. The tour company would have formally notified the insurer, but that the claim would nevertheless still only have been issued following the 2016 pre-action protocol letter.
I don't think I'm going to make that concession. It's an interesting question. I can understand one saying, "Oh, well, that's what happened anyway." But actually, if you're being invited to make this early notification, I don't know what that would have happened then to the claimant and how she would have approached her case. I know that as a matter of what did happen.
Why would it have been any different?
Because she's being given a steer in relation to taking steps, and I don't know if that would have triggered.
Having taken those steps, she's then shored up, and therefore she can sit back. I mean, the fact is that for reasons that are entirely understandable, and one isn't criticising her for it, she didn't respond to Irwin Mitchell for quite some time. They then sort of carried out their preliminary investigations, and they got to the stage where they felt they were able to secure funding and so forth for her by early 2016, and that's when the claim arose. So at the moment I can't see any basis on the counterfactual for suggesting that anything different would have happened.
Well, my lady, whether or not that's the case, and that's part of my leaning in favour submission, because we don't know, because she wasn't in that material position, she was in a different position. In any event, starting in 2016, we then reach a point when LOCOS goes into administration, which I think is something like July or thereabouts 2016, after which the point will have been a live one, I put it that way. And then when it's a live point, the question, the ultimate question that arises is, would the claim have still been settled for value?
Well, I think you can do better than that. It would have been live. We know it would have been live because Plexus Law raised it. When the letter before action was sent, they specifically raised the excess point.
Yes.
So you can say it's pretty certain it would have been a live issue.
It's a live issue, and my submission is, it's not a term that we even say delivers for them as they say they would. So if they're right, then legal advice should have been given to the claimant, would or should, and leaning in favour, if you accept my submission that this clause would not bite as a precondition to indemnity in the way of a pay to be paid clause, then advice would or should have been given to that effect. The claimant has a valuable claim and would have continued. And then either it goes all the way to a trial, and that's when in my submission we get to that point of answering that question, but much more likely the case settles, because that's what happens all the time. And that's something of value, and that's been lost, and that's professional negligence paradigm. Your Lordship again has the submission, if I can.
Yes.
My Lord and my Ladies, I don't seek to enlarge any further unless I can assist the court.
No, thank you very much indeed. Mr. Warnock.
My Lord, my Ladies, I'll start, if I may, by going back to the facts. Because what we submit is that the beginning and the end of my learned's case in relation to the 19th of May 2014 is the judge's finding on paragraph 121 of his judgment at page 140. It begins at the bottom of page 139. Bottom of page 139, it's paragraph 121. The limited basis on which the helpline worked was explained to Mrs. Miller, as I find, during her conversation with the claimant on the 19th of May 2014. Miss Halliwell gave Mrs. Miller some limited high-level generic legal advice about personal injury claims, and this is the important bit, but did not purport and cannot have been understood to be complete or comprehensive legal advice about her claim, and it was a preliminary to further consideration. And that finding is rooted in Mrs. Miller's own evidence, and if the court would like to see it, could I invite the court to turn to the supplemental bundle at page 12. Supplemental bundle, page 12, and it's paragraph 6, where Mrs. Miller described how she, on the 19th of May, saw the advert on the TV from the defendant in this case, which advertised I should call their legal helpline. I thought it looked suitable given my circumstances. As noted, I was in hospital and I called the helpline from my bed and left a message for them to ring me back, which they did. I have seen the defendant's attendants noted that telephone call, although I cannot now remember any detail, except that the matter was to be referred to others and I would hear back accordingly. And then she was questioned at trial about this at page 350 of this bundle. And between letter B and C on page 350, she was asked, and as I understand it on your witness statement, you can't recall any detail of the call except that you recall the matter was going to be referred to others and that you would hear back, yes. Accordingly, would it be a fair summary to say at the end of the call you didn't know whether Irwin Mitchell would be able to help you or not? The first phone call, yes. No, they said somebody would get back to me, right, on it. But did you know whether they were going to be able to help you or not? I can't remember. Okay, because you were expecting to hear back from someone. Yes. And were you expecting that person to discuss your case further with you? Yeah. Yes. Yeah, I think so. Yeah. And of course, at this stage, you hadn't provided Irwin Mitchell with any documents. No. So at the end of that call, would it be fair to say you knew someone was going to call you back, and you also knew that person would want more information from you? Yes, basically, yes. And then the call back did come, as we know, and staying in this bundle. The call back came the next day. And at page 187 of this bundle, that was followed up by the letter of the 20th of May 2014.
Yes.
Which we've already looked at from the purposes of the information it asked for, but it is of note that in the third paragraph it said, in order for me to accurately assess the prospects of your case and to establish whether we will be able to achieve a successful outcome from you or for you, I will need this documentation. And then it's set out. And then at page 188, in the penultimate paragraph, it said, once I've taken the opportunity to review the above documentation, I will contact you to discuss whether we are able to accept your case. Now that then was followed up by another chaser at page 189 on the 7th of July. And when that still didn't elicit a response, a letter of the 22nd of July 2014 at page 190. And what I draw attention to in that is the third paragraph in bold. You must be aware that no action has been taken by my firm to establish what limitation would apply to your claim or to protect your right to take legal action in any jurisdiction. And it carries on in that vein with a similar letter to that. I'm not going to take you to every letter, but again at page 196, that is repeated.
How would that help if a duty of care was breached on the 19th?
What it helps with is looking at what was happening on the 19th. As my learned friend has rightly said, all of the cases say one has to look at the context. And all that happened on the 19th was, as the judge found, there's a preliminary discussion between the parties where they decide to speak again and follow up. So what this demonstrates is that that's all that happened.
But if the case had depended upon the giving of detailed legal advice or a complaint that detailed legal advice was not given, then see exactly where you're coming from. But the claimant has put a case on the basis that it was advertised as a legal advice helpline, and Irwin Mitchell asked how they could help. And some advice, the judge found, was given, albeit at a generalised and high-level advice. And that advice included proper advice being given about what limitation period was.
Yes.
And so really it's a question of, within that context, given that there was advice that was proffered, was the duty of care confined to that which was actually discussed, or was it wider than that, as is claimed, as a necessary concomitant of giving that advice? Was a misleading impression given to Mrs. Miller that she could sit back and do nothing, or and was there a duty to correct that misleading impression if it was? That's how the case is being run, as I understand it.
Where the correspondence helps is it helps in establishing what was discussed, because what the judge said was she was given some preliminary advice. And part of an assumption of responsibility duty being founded is there has to be reasonable reliance upon what is said. And what the correspondence demonstrates, and as the judge accepted on the evidence he heard from the witnesses, is that everybody understood that the advice which was given on the 19th of May was something which needed to be looked at in more detail. And I do, with respect, have some difficulty with my learned friend's submission that even in relation to whatever was said about limitation in very general terms, that there could be reasonable reliance on that when you have two letters which the claimant accepted that she received, saying you must be aware no action has been taken by my firm to establish what limitation period would apply.
Well, surely you'd go so far as to accept that if the person on the other end of the helpline had said the limitation period is 6 years and there'd been no further contact between them, there might be some grounds
Yes,
for complaint.
Yes, I would have to accept that because obviously, insofar as advice is given, it must be accurate. But what I am saying is what this correspondence demonstrates is the advice that was given in very preliminary, broad terms, and was then corrected insofar as Mrs. Miller, if that was the case, because this isn't how the case was put below, or indeed in the skeleton argument that it all turns on limitation. But in relation to limitation, is then expressly told, but actually we haven't looked at this for your case. You must be aware no action has been taken to establish what limitation period. Reliance has to be reasonable.
Well, for these purposes, are we not being asked, and you may say it's not the right thing to do, but are we not being asked to look at the 19th of May phone call on the assumption, effectively, that after that advice, Mrs. Miller had no further contact with Irwin Mitchell and acted on the basis of that phone call and that phone call alone?
Well, it does sound like that's what you've been asked to do. Well, I submit
Yes.
that it's first of all, it's wholly unrealistic.
But
Secondly, it's contrary to the evidence.
But insofar as we're looking at what was the duty assumed on that date, and whether or not what was done on that date was negligent, is that not the basis we have to proceed in the first instance?
Well, no, because the first thing we have to establish is what was discussed on that day, and the judge made findings about that,
Yeah.
which was that it was a very preliminary advice which was to be followed up. And
Well, only if Mrs. Miller chose to. She might have decided not to follow it up.
well, then she couldn't reasonably have relied on it.
Why
is
not?
what I would submit.
Why not?
Because she's been told it's preliminary and someone's going to call her back. I mean, in fact, as the facts go, she does. There's no dispute that she received these letters.
Yeah. Let's
But
assume somebody calls the helpline for legal advice and is told you have 3 years limitation period, and decides as a result of that, well, that's fine. I'm in hospital. I've just had my leg amputated. I'm not in a position to deal with this at the moment. I'll come back to it in 2 years' time when I've recovered. And they do that on the basis that Irwin Mitchell has told them on their legal advice helpline that the limitation period is 3 years. Now, are you saying that they weren't entitled to rely upon that advice about the limitation period?
No, I'm not saying that, because all these things depend exactly on what was said and what the context is, and I'm certainly not saying that. If someone was told definitively, you've got a 3-year limitation period, nobody corrected that later or chased it up if that was wrong. Supposing, for instance, it was an aviation case where there was a shorter limitation period, then plainly, if a cause of action was lost because of the limitation period having expired, there would be liability for that. But we're so far removed from those facts because firstly, we have the judge's findings about what was said in that call. And secondly, Mrs. Miller is not left in a position where she's sitting in hospital for 2 years thinking in relation to limitation. I'll come on in a minute as to why limitation in any event has nothing to do with what's gone wrong in this case. But she's not been left in hospital thinking, well, it's 2 years, because in fact, that may well be what she thought. But if one's in the context of assumption of responsibility, what the claimant themselves thinks isn't enough. It has to be reasonable.
Yes.
And the reasonableness has to be judged in the contexts of the fact that there's no dispute that Mrs. Miller received letters later telling her that the limitation period was not actually ascertained. I'm putting this is not, if it sounds like I've not put this in my skeleton before, it's because this isn't the way the case has been argued before.
I agree, I
and
understand
hence
that.
I'm now focusing on reasonable reliance in
Yes.
relation to that.
But I think the point is that limitation isn't being put forward on the basis that the advice in relation to that was wrong or negligent or it wasn't followed up properly. It's being used as a hook.
Yes.
And it's being said, if it is right that there was advice about the limitation period, and it seems that there was at least some advice about the limitation period,
Yes.
however provisional, preliminary, then wrapped into that is the assumption of responsibility as to timing issues. And timing issues included, it is said, the need to warn the claimant that time may be ticking for notification.
Well, where does timing stop? I mean, really, timing that you should get your witness statements quickly because we've all had unexpected cases where witnesses die. Timing that you should get your documents together. You know, it just, where does it actually stop? It's putting too much on a limitation argument. An assumption of responsibility in relation to limitation is advising somebody about how they might actually lose their cause of action by reason of it becoming time barred. It doesn't carry with it an assumption to advise on every other aspect of a case, let alone carry with it an assumption to consider the creditworthiness or financial position or insurance position of the defendant. Those issues go way beyond an issue of limitation, which is all about not losing the cause of action. It doesn't carry with it any advice that your case is a strong one, that it's a good one, that you'll win. It doesn't carry any advice beyond the fact that you won't be able to sue at all if you don't sue within 3 years. And it is relevant in relation to assumption of responsibility to always ask what it is that the defendant is assuming responsibility to do. And that was a point made by the Supreme Court in the HXA case recently, and perhaps it's just worth looking at. It's in the Authorities Bundle, tab 3. And it's page 714.
Which volume?
Volume 3.
Volume 3.
It's HXA and Surrey County Council. Sorry, tab 25. Thank you. 29. Thank you. Decision of the Supreme Court last year. It concerned, I'm sorry, HXA and Surrey County Council 2023 UKSC 52. The issue was whether social workers who had carried out child protection assessments and made resolutions to seek legal advice about taking a child into care had thereby assumed a responsibility to the children in tort. And at 714, paragraph 91, paragraph 90, the Supreme Court referred back to the cases my learned friends referred to, such as JPSP 4 and Royal Bank of Scotland. For the paragraph 91 that Lord Burrows said, it's very common for the language of assumption of responsibility to be used at a high level of generality. However, it helps to sharpen the analysis, always to ask what it is alleged that the defendant has assumed responsibility to use reasonable care to do. Now, below the argument was, well, the defendant assumed the responsibility of a solicitor to his client to generally protect the client's interests, and then there's an argument about what the scope of that is. In fact, that case rightly isn't pursued because on the judge's finding, there wasn't a solicitor's-client relationship. So my learned friend now says, well, the duty was to advise on limitation, but that really can't go far enough. What he's really alleging is that there was a duty on the part of the solicitors in that early call to advise Mrs. Miller to consider the insurance position of the
Well, how do
defendant.
you frame what the assumption of responsibility was on the 19th of May call?
In terms of the advice that was given, in terms to make sure that reasonable care was given, that the advice which was given was accurate. But it doesn't extend to considering the insurance position of the defendant.
Reasonable care to ensure.
That such advice as was given was correct.
So that effectively, I think, just says whatever you expressly articulate has to be correct.
Yes.
I don't think you're accepting that there is any minimum level of what you need to articulate. Say, for example, if nothing was said about limitation.
No, one would have to be careful. I think it's personally, I think it's probably a good thing that solicitors advise on limitation if somebody phones up, and I wouldn't want to say anything to.
I think for today's purposes, you're saying it's just to ensure that what was said
Yes.
was actually
Yes.
accurate.
Yes.
So if they said nothing at all, then there's no question of any breach or any duty.
Well, that's one of the quirks of assumption of responsibility, is that if you do nothing, you haven't assumed a duty to do anything.
Well, you are doing something.
Mm.
You are answering what is described as a legal helpline. And that is doing something.
Yes, it did. It does do something, because one of two things will happen from that call. The client will either think they've got a case that's worth exploring further because they're going to be referred on to the team that will deal with it, or they will be told, actually,
Well, don't they think
nothing-
they, don't,
nothing
they
here
think
that-
don't they think they're going to get some legal advice?
Well, I can only deal with the case as it is.
Yeah.
But some legal advice was given.
I mean, I must say, speaking for myself, if one tested it this way, and the client rang up with a week before the limitation period was due to expire, and the person on the legal advice helpline didn't tell them that that on the basis of what she said about the accident
Yes.
when it took place, oh, by the way, you'll need to get your skates on to get a claim form out to protect you against limitation because the limitation period's about to expire, I can see a pretty powerful argument that there was a duty of care to tell them that, even though there wasn't any express statement about limitation.
Yes, it may be that that's embraced with the fact that you've taken the call and somebody phoned you up in those circumstances. And
We may not need to decide it,
No.
because the fact is that advice was offered about limitation, and so we don't have to deal with that.
Yes, and Irwin Mitchell's advice was in the evidence was in the circumstances which my lady's just described. The client would be told, even if they couldn't take on the case, that there's only a week of limitation left, go and see someone. But that's obviously not the case we're dealing with here. We're dealing here with it saying that the solicitor in a preliminary conversation, which may or may not lead to a claim, may or may not lead to a retainer, is being told that they have to foresee during that conversation that you might have a position where the other party has insurance, has not complied with the notification clause of that insurance against their own interests, and that is really, I would submit, rather sophisticated advice to be expected to be given in a call of this nature.
Well, I don't want to push this too far, but in my understanding is that the person who answers the call and completes the form is described as the legal advisor.
Yes.
And that the guidance notes say that legal advisor will provide legal advice as required.
Yes.
To explain the reasons for capturing information.
Yes.
It certainly sounds as though they're accepting that they're giving legal advice of some sort.
Yes, but I think the issue here is whether they're giving advice on because, as I say, I come back to the question has to be, what is the assumption of responsibility which is alleged?
It's the scope of it, isn't it, really? It's the scope of the legal advice. The legal advice is very general, high-level advice in relation to what you need to show in order to win a case. You know, the ingredients of the claim in tort, personal injury. And on the facts of this case, there's preliminary legal advice about the likely limitation period. And that's about it. And the question is, does that latter piece of advice about the limitation period create a misleading impression, is the way that it's put against you. It creates a misleading impression that you can sit back and do nothing for 3 years.
Well, with respect, it doesn't, because it's a different point. I mean, the defendants may have prospered in the next 3 years. It's the limitation advice is purely in relation to the limitation. And we've set out, I don't want to just laboriously go through our skeleton, but my learned friend has taken you to cases such as Carradine. There's also John Molam in there, which are cases where solicitors have been advising their own clients about their own, or it's been alleged they should have advised them about their own insurance position. And in both cases, the duty wasn't found, albeit I accept entirely it's a question of fact in each case. Nonetheless, it is of note, there is no case where a duty has been found where solicitors owed a duty to advise their client not about their own insurance position, but about the insurance position of their opponent, absent anything to put them on notice that there's a reason to do so. And of course, we are in a realm here with, although we know that the defendant had a public liability policy, and it's likely that most big tour operators will have public liability policies, although there's no legal obligation on them to have it. And they have to have insurance to cover people's holiday costs when they book a holiday, that they're able to refund it if they go bust.
And the package tour regulations.
And the package tour regulations, but they don't actually have any legal obligation to carry public liability insurance. As a matter of practice, the expert evidence was they generally do. But it's also of note that they often carry huge excesses. And in supplemental bundle, page 57, the evidence of Mr. McGregor, the defendant's expert, was at paragraph 2.5 on page 57, that the travel operator's liability policy will have a policy excess for each section. The excesses vary from 0 to 1 million per person. And the other thing to note about this case is when Mrs. Miller first phoned up Irwin Mitchell, it was a general damages only case for a broken leg, a nasty break of the leg, but a broken leg nonetheless.
Yes, the amputation didn't come until November 2015.
That's right.
So it wasn't £1 million claim. It was quite a lot smaller than that.
It, likely well within the excess aggregated that the judge's finding that a duty to notify the other side, to notify their insurers, arises only at the point of the retainer, in fact, at the point when the letter of claim is sent, when you're in a position to send the letter of claim, actually accords entirely with the position under the pre-action protocol. And of course, that makes sense, because if a solicitor writes to a party saying, well, my client's making a claim against you, that is an act which very likely will trigger a notification obligation. So the Solicitor's Act actually creates the risk. And viewed in that context, it's not at all surprising that the pre-action protocol says that solicitors should notify in that letter. It's very striking that it doesn't say that should be done, even if just notifying the defendant of the claim beforehand. It says you may do it, and even then, only if it's known there's likely to be a claim that's going to be brought. Which of course wasn't known here until such time as Mrs. Miller got all the documents together. Irwin Mitchell were able to ascertain that there was a liability under the package holidays regulations potentially, and they had her case, her information as to the detail of the accident, and that's the point at which the letter of claim is sent. I don't want to bore the court with going over ground we've already looked at, but the Crossman and Bracewell case is entirely on point in relation to the judge's finding. There, the solicitor undertook a task of advising on how the client's defence could be funded. And his advice as to how it could be funded was incomplete. That's the basis of the finding of liability. Just as here, if the solicitor, Miss Halliwell, or the advisor, Miss Halliwell, had said, well, it's a 3-year limitation period, ignoring the fact that it was an airplane crash, she could rightly be criticised. But it is of note that the judge considered there wasn't a duty even then in relation to the client's own insurance policy to look at wider issues of notification pre-retainer. We've set it out in our skeleton in the passage that the judge also quoted. We also submit that our position that my learned friend's case is a stretch for any number of reasons is also supported by the point we've taken in our respondent's notice, which is that, and this is in our skeleton argument, at page 63, paragraph 39 onwards. The scope of a solicitor's duty does not extend to the risk of a judgment not being enforceable due to the defendant lacking the funds to meet it, unless he is put on notice of potential impecuniosity of the defendant. And in support of that, can I take the court, first of all, to the current edition of Jackson and Howell, which is in volume 3 at tab 31, page 744. And you'll see an issuing proceedings at 11185, the sidebarred part. A solicitor has no general duty to verify the creditworthiness of a proposed defendant. before commencing proceedings unless there are specific indications that something is wrong. And that also was the holding of this court in the Pearsons and Weatherspoons case, which is at tab 15, which is volume 2, I believe, at page 364.
Can you give that reference again?
It's volume 2, tab 15, page 364. The facts were it was they're rather complicated, but it was a claim for breach of contract. There were lots of rumours in the press and media speculation that the defendant was having financial difficulties, and the judge and the Court of Appeal held there came a point where those stories were concrete enough that the solicitor was put on notice that the defendant might not be able to pay. But in the results, by the time he got his judgment, there wasn't any money left to pay him. And he then sued the solicitor saying they should have paid him more quickly or pursued the litigation more quickly. But he sought that to be assessed on the basis of that there were general failures to prosecute the case, and that as a consequence he was left in a position where he suffered larger losses because the defendants went under. The Court of Appeal held no, he couldn't be liable for any losses which were suffered of that nature until such time as the solicitors were on notice that impecuniosity was a real risk. And the relevant holding is at page 379 in the judgment of Lord Justice Ward, with whom Lord Justice Chadwick and Lord Justice Peter Jackson agreed. And it's at letter D, and we've sidebarred it on page 379. Then in my judgment, the duty of the solicitor in accepting the retainer to act for a client in litigation is the duty with all due expedition and not to cause delays. The kind of loss against which it is the duty to safeguard the client is the kind of loss which flows from the loss of the right of action, as where the claim has been struck out. The loss flowing from the inability to enforce any judgment actually obtained is, in my view, a different kind of loss. It is at a loss one removed from the conduct of litigation to trial and judgment. Mr. Justice Gage was right to have regard to the general policy and to the notions of justice and fairness to decide whether the duty extended to cover that risk. With respect to him, I disagree with his conclusion. In my judgment, policy demands that delay in litigation be eradicated, but those demands do not extend as far as imposing upon solicitors the risk of non-recovery of a judgment debt. Reasonableness, fairness, and justice as between solicitor and client do not require the imposition of a duty on the solicitor, arising simply from the retainer to protect the client against the risk of a judgment not being enforced through impecuniosity of the defendant, at least without responsibility being assumed by the solicitor, or sufficient notice of that impecuniosity making it reasonable, fair, just, and reasonable to extend the duty to that loss. Here, foreseeability of the collapse was sufficient to trigger an extension of the duty, was not sufficient until the press reported their future was dubious. And he goes on to say they shouldn't be held liable for the period before that. And what I submit is a fortiori here, where you don't even have a retainer or anything like it.
I think the way the case is put against you is that even in the absence of a retainer, it's well known in the market, and the judge so finds that travel insurance policies of this nature will usually have or often have clauses which require prompt notification after the incident. And that's something that you would expect Irwin Mitchell, a specialist, to know about. And therefore, that is, if you like, the analogy between being put on specific notice that there are financial difficulties with the insolvent defendant.
Well, I'm not. Hadn't my what the judge. What's common knowledge is that there are notification clauses, and I hadn't, for my part, understood the judge to be saying what was common knowledge was that there would be a clause that would operate like this, because it is of course common knowledge across the industry that there will quite often be a notification clause when you make a claim, hence the pre-action protocol, and indeed that's what the judge actually found. He didn't find there was some earlier duty to notify. He said it was at the when sending the letter of claim that the duty arose. I think this brings us into the so-called adverse inferences point. And we haven't troubled you with the authorities on that because there's no dispute between us that the law in relation to that is as set out in our skeleton argument. If I can just find paragraph 42, page 65. And we've not put the FOB and Royal Mail Group Supreme Court case from 2021 in the bundle because we were told it's the proposition that's set out here is accepted, that to succeed on this argument, Mrs. Miller would need to identify the inferences and show on the facts of this case that no reasonable judge could have omitted to draw them. And with respect, the inferences that were invited or set out to my learned friend's skeleton argument at paragraph 86, page 42. With respect, they fall at the first hurdle when one's in an industry where excesses are often up to £1 million. Where it said that they expected any damages awarded to be paid by low-cost insurers. And we all know, those of us who act in personal injury litigation, that frequently claims are made out of the insured's own excess. And that would be particularly the case if you're talking about excesses. Well, in this case, we know the excess was over 500,000, can be up to £1 million. And you're talking about a damages claim, which when it first come in is for a broken leg without an amputation or any talk of amputation.
That's quite an important point, and until you made it, I hadn't completely taken it on board. But of course, nobody is contemplating £1 million claim until the sad occurrences of November 2015.
And that's no one's fault.
No.
Not Mrs. Miller's fault, because
No.
she only found out 2 days before the amputation that that was what was going to happen, and not Irwin Mitchell's fault, because for those reasons she hadn't told them.
Well, the infection hadn't really developed, had it? I mean, it had been noticed, but it was only described as a slight infection at the time when she phoned Irwin Mitchell.
Yes. That's why it was originally, you may not have picked this up from the judgment, I think it is in there. It was originally referred to the fast track team.
Yes. Yeah.
And no criticism was made of that. There was no allegation that somehow Irwin Mitchell had misvalued the claim at the outset or misunderstood its potential. And as we say at paragraphs, going back to our skeleton, at paragraphs 28 and 29, page 60, there's an attempt in this case just to say, well, it's just a case that you were supposed to, write to the defendant. Doing that in itself is potentially problematical because it said either the solicitor should have done it or Mrs. Miller should have been told to do it. Well, those of us who act regularly in this sort of litigation are only too aware of the dangers of somebody's a client being let loose to write a letter themselves about what happened if one hasn't seen what they've already said about it, or they may have forgotten or inadvertently create an inconsistency. And the solicitor clearly couldn't write a letter unless retained and on the record. But the real problem is, and it's paragraph 28, the problem that Mrs. Miller's claim was ultimately to meet was not that low cost didn't know about the accident, but that they did. And I have to say it came as a surprise this morning to hear it being suggested that somehow low cost didn't know, because the whole case.
Surprise to me as well.
Well, if they hadn't, if that was the position, then it shouldn't be Irwin Mitchell that's being sued. It should be low cost, and then somebody stepping into the Third Party Rights Against Insurers Act. But it was common ground below, and that is my learned juniors also reminded me of my learned friend's predecessor's opening below in the supplemental bundle at page 340. But before I go there, paragraph 29, we set out that this is what she really has to establish, is the duty to advise, ensure that low cost or potential opponent in contested adversarial litigation complied with its contractual arrangements, even though it's res inter alias acta, and even though they don't know what those arrangements are. But in relation to the fact that this wasn't an issue below, if we could just go to the supplementary bundle. I'm sorry to jump about.
Sorry, which page?
Page 340. It's the skeleton argument from Mrs. Miller below. Is it 243? Sorry, 243, page 243.
243.
243, I'm sorry, it's a bad reference on my.
This is the claimant's skeleton.
This is the claimant's skeleton. And at paragraph 30, you will see that the claimant's case is that the evidence was that the LTS was informed of the incident on the 15th of May, and the LTS informed low cost the same day. I don't know why the judge has put it slightly differently the way he put it in the judgment, but this wasn't actually an issue.
Yes, well, Mr. Weir didn't appear below.
No. So those are the submissions I make in relation to the assumption of responsibility and its scope. In relation to the notification clause, I think we've set it out in our skeleton. It's not been pressed before you by my learned friend this morning as a ground of appeal. But there was no dispute in this case that HSEC were entitled to rely on the notification clause. The second point is that they actually did so. The case is actually quite, my learned friend mentioned Phillips and Waitley, albeit in the context of the excess. But Phillips and Waitley was quite different on its facts, because in that case, the insurers never actually took the late notification point. They didn't have to, because, and if they, the case got time barred by reason of the solicitor's negligence. And far from not taking the late notification point in that case, the insurers actually went to the trouble of nominating solicitors to accept service of the proceedings, and when a default judgment was entered against them, taking steps to instruct solicitors to set that aside. So Phillips and Waitley, on the facts, the Privy Council took the view, well, nobody knows whether these solicitors would have taken a late notification point or not. They say now they would have done, but who's to say they would? In our case, we know that in fact they did take it. The only issue is whether they would have taken it a year earlier. And the judge had ample grounds to make the factual finding that they would have done, because he accepted the evidence of the experts, which was agreed evidence, that this was a hard market and insurers would take any point that they could. And hence, by April 2015, there was no prospect they wouldn't have taken it. In relation to the excess clause, again, actually, we know the insurers would have taken it because they did take it through Plexus, albeit later than they took the notification point. And it was in the letter at supplemental bundle, page 217, the one that we looked at earlier.
Let's have a look at that.
Supplemental bundle 217.
The 23rd of August 2016
Yes.
letter.
Although, I mean, it makes the notification point first.
It does.
So
It says in
that
any
is- You
event.
could say that's relevant context to
It's certainly relevant.
throwing in
context.
another point.
Yes. But the fact is that they did throw it in because the argument, it's on page 218 that they take it at the top. The argument that is made in my learned friend's skeleton is, well, this is a very unattractive point and they would never have taken that. Well, that's what was said about the notification point in Waitley, and they took it. Here they are taking the excess point. In relation to the nature of the clause, and that was an issue which the judge was asked to decide, actually, what was the effect, the meaning and effect of the clause. That was one of the preliminary issues. It's at,
It's issue 7.
yes, page 10 of the supplemental bundle. The proper construction and effect of the annual aggregate excess clause. As a preliminary point, we would ask the court to note this. This was not a pay the claim to be paid clause. It was pay the excess to be paid clause, which is quite different. So it's not quite right to say, well, all those policies and commercial reasons that apply outside the marine context in PI clubs don't apply, because we're talking about a different type of thing here. It's also in that sense not like the charter case where it was being suggested that the insured had to stump up the entire cost of all the costs of the aviation crash. It's purely the excess.
Well, if the excess, if it had simply been a standard excess clause of 10,000 or whatever per claim, you can see entirely that why that might be a distinction, a good distinction. The problem is that your aggregate excess is 560,000, which is quite a lot of money.
It is.
Even for a tour operator to have to stump up. And why, in your submission, does the commercial reason for reading that differently in claims cases not equally apply when it's said, certainly in the professional indemnity insurance context, it defeats the purpose of the insurance by requiring the assured to put their hands in their pockets for a sum of money they might not be able to afford before the insurer is on the hook?
Well, I'll set aside for a moment an argument based on what Lord Mustill said, that there doesn't actually have to be a commercial reason if that's what the policy says.
Yeah.
But in relation to the commercial reason, the evidence the judge had before him from the experts was that insurers at this time were experiencing a very huge number of claims and poor claims records from the travel industry. Largely, it seems, driven by food poisoning cases. And so insurers had increasingly hardened the terms upon which they would be prepared to indemnify. Hence, clauses that became more strict about what the insured had to do before the insurers would take on a case. Insurers were essentially wanting to say to the travel industry, not our problem, because this claim that is within your aggregate. So that's the commercial context. And requiring the insured to pay the excess, not the entire claim if it had been a claim for 2 or 3 million, but just the excess, including the aggregate excess, has to be seen in that context.
Or requiring them, let's play devil's advocate for a minute. Let's suppose that the claimant is right in terms of the interpretation of this clause. So it's all that's required is to show that they are liable, rather than they've actually shelled out the money. Right. That still presupposes that before the insurer dips its hand into its pocket, there is some evidence before it that they've exhausted the 560,000 over and above the 10.
Yes.
And it seems to me that in practical terms, the only way you could do that is by pointing either to settlements or judgments to that quantify.
Yes.
And am I right? There's no evidence that was put before the judge at all as to whether they'd be able to do that, other than the fact that they could show that they settled £5,600 worth.
So that's right.
Well, unless you effectively assume it's netted out of this particular claim. In other words, if you assume this claim is for well in excess of the excess, then you're assessing what you insurer might be liable to pay when it comes to it. You might assess what you're prepared to offer in the settlement scenario.
Well, you might.
With that in mind.
Yeah.
I
mean,
think that may be the way the case is being put.
There's a point on evidence here, because there is no doubt, contrary to what has been submitted in the My Learned Friend's skeleton, which was written by his predecessor. If one's into the realms of loss of chance of what would have happened, the burden isn't on the claimant to establish that there was a real
rather than fanciful.
Yes. Now, it is of note in this case, the schedule which we have, which sets out how the excess had been accumulated and how much of it was left, that was actually obtained from the insurers by the claimant's solicitors. It was perfectly open to them if they wanted to say, well, there's a chance that the insurers would still have paid this, to have called evidence of that nature. In terms of the meaning of the policy, and I speak with some trepidation in the presence of the court, I'm in the presence of, I do draw attention in the charter case, because the charter case actually, this so-called pay to be paid clause in the charter case was actually buried away in a definition section. It wasn't, as in this policy, set out in a section called General Conditions of the Policy. It was, as I say, in the definition. And at page 336 of the authorities bundle, it's tab 13 of volume 1. sorry, 335 is the page I want to go to. Lord Mustle's speech.
Well, it was an excess of loss clause, wasn't it?
Yes.
It's very different.
Yes, and it was the context of the liabilities between top layer and insurers and so forth. But he said at page 335, there's a passage that's sidelined, which I think my learned friend may already have taken you to. But he sets out he's dealing with it in a very specialised form of reinsurance at letter G. And he looks at the whole structure of the policy. And he says that at page 336, letter B, he says this argument draws strength from the shape of the policy. And as I've already suggested under this form of words, although perhaps not under all forms, the policy covers not, as might be thought, the suffering of loss by the reinsured in the shape of a claim against him under the inward policies, but the occurrence of a casualty suffered by the subject matter insured through the operation of an insured peril. The inward policies and the reinsurance are wholly distinct. It follows that in principle the liability of the reinsurer is wholly unaffected by whether the reinsured has satisfied the claim under the inward insurances. This result can undoubtedly be changed by express provision, but clear words would be required. And it would, to my mind, be strange if a term changing so fundamentally the financial structure of the relationship were to be buried in a provision such as clause 2, concerned essentially with the measure of indemnity, rather than being given a prominent position on its own. And as I say, it was buried in the definition section, actually, as to what would constitute the net loss in the case. And he goes on to say that to deal with arguments, well, you couldn't have a clause like this, and he refers to the Firmatrade at letter F. And at letter G, he says, sorry, that's the Fanti case. At letter G, he says, these arguments are fully explored in the judgments delivered below. Intending no disrespect, I do not intend to enter them here, for in my opinion, they cannot be cancelled. This is about commercial meanings and so forth. If, as I believe, a proper reading of the policy discloses no condition precedent, there's little profit in considering whether it would have been absurd to include one. If, per contra, the words actually paid can only as a matter of language and context mean what the syndicates maintain, I would hesitate long before giving them any other meaning, just because the result would be extraordinary.
I think the case that's most difficult for you on the construction point is Teal Assurance, which is at tab 21.
That's
Tab 21.
Lord Mance's judgments.
That's the 2013 case, because it was a professional liability insurance, and I think that the problem that was identified was that it was treating a quantification clause as if it were a condition precedent to liability. I think that was the way in which it was decided. So if one looks at just the head note on page 470, the ascertain that by agreement, judgment or award of the insured's liability gave rise to the claim under the insurance which exhausted the insurance entirely or pro tanto, but the insurance had a limit. It made no sense to speak of the insured having causes of action or recoverable claims which together would exceed that limit. So
as I understand it, the issue in that case was, and I have to confess I find the facts rather complicated, but the issue in the case was that, in a sense, one of the top layer insurers, but not the very top one, one of the intermediate excess layer insurers, was trying to sort of rig it to fix their limits of indemnity.
that's right.
So that they could try and recover past claims on to higher level insurers who otherwise wouldn't be on the hook for them, because they were what they were trying to do was they were receiving claims in, but they were deciding themselves, well, we'll treat this claim here's some money that we're going to pay. We'll treat that as paying this second claim because that arose outside Canada or the United States. And therefore that still leaves us with a nice chunk we can pass on to our reinsurers for the first claim we received. And the Supreme Court held we couldn't do that because they were, they had to deal with the claims in the order they came in.
I think that's right, but is there an analogy to this extent that, as you say, the provision here deals with the excess, not with the tranche, if you like,
Yeah.
to which the policy is responsive. And equally here, you're dealing with a different layer. In other words, it's not like the P&I Club case where it says the very thing we're insuring you've got to pay out before we pay you. It's, or appears to say on one reading, you've got to discharge an element that we will never pay anyway before we pay ours. It is distinct, and to that extent there is an analogy with the case we're looking at now, because that's also looking at a different layer, if you like.
Well, it is true they're looking at a different layer, but it is important that on the facts, payments, as I understand it, were being made in this case. It's just that the insurer was choosing to the insurer who was seeking to run this argument was seeking to allocate them to one claim rather than the next. So, but payments were being made, and it is in passage that my learned friend, I don't think, did take you to in the judgment of Lord Mance at page 482. His judgment's actually rather tentative on this point. We looked at paragraph 21, I believe, where he said it's not certain that the word paid means dispersed. But at 22 he said, third, even if the word paid here means dispersed, a requirement of disbursement as a precondition to recovery from the insurer says nothing about what has to be paid for a right to indemnity to arise under the insurance. It means only that as and when expenses and third-party liability are incurred and ascertained, they become recoverable under the insurance, provided that the insured first disperses an amount equivalent to the deductible and self-insured detention. It does not mean that the insured, by delaying such disbursement and choosing to make a disbursement in respect of different later ascertained expenses or liability, can alter the order in which the policy and the insurance programme to which the first ascertained expenses or liability attach, nor does it give the insurer the right to say it will only provide indemnity in respect of later ascertained expenses, so promoting the claim in respect of such expenses or liability ahead of the claim in respect of the earlier ascertained expenses. So he's actually he doesn't actually go so far as say this is what it definitely says. He expresses in paragraph 21 to it's not certain that it means dispersed.
But he then goes on in paragraph 23 to explain how it operates in practice.
Yes.
And it's very similar to the proposition that my lady put to you, which is that when you've got a claim, you take into account the expenses and third-party liability, use that up as self-insured retention and deductible, that's the excess, and then the policy will respond up to its limit. So it works like the different layers of a cake. So with the top and drop, effectively, you don't actually have to pay it out. You just take that into account in doing the overall calculation of what is due, which is all well and good when you've got one claim. When you've got a proliferation of claims and an aggregate clause, it's a bit harder.
But I don't think I can take it any further. As I say, we say there's a long way before one gets to this point in the case. That has to be overcome. But those are my submissions on it. I should just briefly mention the Australian case. Doesn't really assist. I mean, interestingly, it refers to a Canadian Supreme Court case that went the other way. But the wording in the Australian case was shall pay, which of course imported into it the possibility that the payment could be made at a future time, as opposed to the wording that we're dealing with, has paid. And as for the suggestion that the word actually should make a difference, if I say it's raining outside, it either is raining outside or it isn't. If I add the word actually to it, it doesn't make any difference.
I think the point was being made that the word actually, which was sort of stressing actual payment in reality, was still not enough.
Yes, but in that particular context of that,
Yeah.
of what was being decided in that case. Those are my submissions, unless there's anything I can help the court further on.
No, thank you very much indeed. Mr. Weir, do you have a reply?
Lord, yes, I'll make a reply which will finish comfortably on the basis that the court normally ends at 4:15.
Yes, thank you.
Lord and my ladies, in relation to the issue of assumption of responsibility, just trying to take it in the order in which my learned friend has raised issues and hoping I don't miss any out. His knockdown points judgment, paragraph 121, I'm afraid, just simply don't follow. The judge has indeed referenced that there is a referral on. He then says, let's look at the referral on and all that the referral on involved by way of letters from Irwin Mitchell. But the question is one not to be viewed with hindsight, it's one to be assessed on the basis, was an assumption of responsibility established on the 19th of May by reference to the legal helpline. And you can't then go and say letters that Irwin Mitchell have subsequently written can reframe or refashion the assumption of responsibility that they are in law held to have engaged in by reference to their conduct on the 19th of May. What essentially is being said is exactly what didn't happen, which is there was no disclaimer. There could have been a disclaimer, there was not a disclaimer. In relation to whether or not my learned friend has actually conceded or recognised that there was a legal duty, a common law duty of care based on the principle of assumption of responsibility arising out of the defendant's conduct on the 19th of May 2014 in relation to the accuracy of his advice on limitation. At one point, or maybe 2 points, my learned friend appeared to acknowledge that to be the case, but then swiftly reframed it by reference to generic high-level advice and by reference to the subsequent correspondence saying, well, by the way, we are not giving you legal advice. But as I say, that's not the way to do it. It's either was or it wasn't. So I'm not sure even now if I understand whether truly that's been recognised and conceded or not. I'm not sure. The CICA example was not put to my learned friend, but I can be pretty confident that he wouldn't accept that the duty of care, if he's conceded it, in relation to legal advice extends to the incidental feature of, and you need to contact the police reasonably practically, or as soon as reasonably practical, or words to that effect. So I don't understand that to be the position. I do make and maintain that is our case, and that then it puts the whole thing in a different context, that my learned friend is simply at pains to resist. However, he accepts from various observations from the court that they're answering a legal helpline. He's either conceding only that it's express, but then seem to back off and to say, well, if it is 2 years and 11 months, maybe there is a duty even to put in more, but then backed off it again. So I don't know where the learned friend lies in relation to these issues. I accept, as I've made my own submissions, that you ultimately have to look at each of those scenarios individually, hence the difficulty of drawing sort of grand conclusions as to the effect of a judgment in this court today were it to make a finding in favour of the claimant, because you can see how careful or cautious my learned friend is being in relation to all these things. He hasn't said, yes, we accept this is the position, but it just doesn't apply here.
Well, his concession was, or what he said was, the assumption was reasonable care to ensure that such advice as was given was correct. Now, correct is quite a broad term in legal advice. because what the actual words you may say may be correct, but the advice may not be because of what you didn't say. So I'm not sure how that it's really that really answers the point either way.
My lord, this is rather the point I'm seeking to make. So what I approached the case this morning on the basis I had to build it up in blocks. And was presented with observations from the court effect. It's even obvious that you have to give advice in relation to limitation, even if you don't mention limitation, which I wasn't anticipating. But that I'm just saying, my learned friend is at pains, as I see it, desperately not to allow this in because he can see where it takes the court. Because once you do recognise first that there is a duty, an assumption of responsibility in relation to the giving of limitation advice, then how we can extend it with that straightforward example of what if it attaches to something else, and going down the same line of the CICA example, and then we now have to look exactly as per your observation, my lord, to my learned friend, of when putting how we put our case to my learned friend. This is not an advice so much about limitation as an advice about what steps need to be taken promptly. And I haven't really had an answer, save of course a rejection of ultimately the conclusion that that's an advice, that that's part of the duty of care. But that's all. And so all I can really do now is, in reply, is identify the importance.
Say you're right.
Of course, I mean,
Yes.
that's conclusory, my lord, and not particularly valuable to the court. But it's more the caution that my learned friend has expressed is notable because of the difficulty that he sees once he allows it in. It was then said it was rather sophisticated advice to be given. It isn't. I mean, the legal advisor was to provide legal advice as required. The pro forma itself talks about this, and I sought to set out in my submissions how it is that the evidence discloses that the defendant understood this was a point of importance and why it was a point of importance. See the judgment at paragraph 126.
What the pro forma doesn't do, and what there doesn't seem to be any evidence as to the training of the legal advisors, is what happens if the answer to that question, if the question is posed and the answer is no, I haven't told anybody yet.
That's why one has to piece the jigsaw together in the way I've sought to do, by taking out all of the relevant strands of evidence and showing first that it's important and secondly why it's important. That's why that's how we put our case, my lady. The observation was then made by my lady Justice Andrews, putting our case to my learned friend, that it was well known in the market that these insurance policies have clauses requiring prompt notification after the incident.
I hope I put it fairly.
For which I wrote exactly in my own notes, but there just wasn't an answer to that, other than the conclusory, that doesn't apply here, it's different. And we may have started today with observations on the grounds it's very different, but I only hope that the court on reflection will see that it's not very different at all, and that two are heavily linked, because that is, as the court knows, is the essence of the case that we're promoting. It was then said that, well, this was a small claim at the time, and my lady considered this to be an important point. I don't say it's not part of the factual matrix, but I do say this, asking perhaps rhetorically, is it being said then by the defendant that if this was a spinal cord injury case, they would recognise a duty? Of course not. No, they're essentially just saying there is no duty, and we're essentially saying there is, and the matter within the context of tour operator claims is being dealt with on that level of generality. It isn't a specific. See again, paragraph 126. It's just how the case has been put and recognised by the judge.
Well, I think the point that was being taken against you was that on that basis there'd be no foresight on the part of the solicitors that there'd be an insurance problem even if the tour operator was insured, because the tour operator would probably mop up the value of the claim.
Well, my lady, not under the excess, because of course this is not known. All you're taking to is expert evidence saying it can be naught and it can be £1 million. The whole point is the claimant and the claimant's legal team don't become privy to that. But there is a recognised problem and a totally straightforward solution to that problem. And if you set up a legal helpline, anyway, then I'll be repeating my submission, but your ladyship has it.
Do you say that Irwin Mitchell should have advised the claimant to notify, or should they just have mentioned that notification was something that should be done?
Yes, I mean I've used the word advise the claimant, and now I'm inserting the word to alert the tour operator. Absolutely.
That they should have advised her to do it,
Yes.
rather than saying that's something that we can help you with if it needs to be done.
Well, I mean, the case has been put on an either-or basis to date. I mean, to me, it makes perhaps more sense to. That's a matter for that's a mechanistic issue. They say it's dangerous to invite the claimant to do notification themselves. Dangerous for a holiday maker to contact a tour operator when she's had an accident. Not dangerous at all. It's exactly if it was.
Well, you advise the claimant about the limitation period, but you don't advise her to issue the proceedings.
No, issuing the proceedings well, you get that issue of if it's 2 years and 11 months, and yet you don't want to take on the claim. You might want to say, if I don't want to take on this claim, you either better rush to find some other solicitors if you're interested in doing so. You have to be incredibly careful in the way you advise in that situation. And you might end up saying, or, I think if I was just imagining myself in that situation of with a barrister, or you can actually issue a claim form yourself. You go and get a document off the court forms and you fill it in and you file it, and this is how you file it. So it becomes a bit fact sensitive, but I consider that, and I don't. It's not to gloss over. If I call it detail, it's not to gloss over it. But that's the detail of it's not for me trying to ignore the content, and I'm not answering that question. What is it? I've gone straight to that question at the beginning.
Yep.
But I do consider that to be a detail of its system, how it chooses to then operate its system once it has assumed that responsibility. Let's put it that way. So I think that hopefully covers in short order all motion substance clause.
Yes,
because
I think it
I
does.
know you will not want me to go further. In relation to the excess clause, just note in relation to the plexus letter, if I can just go back to it, if you like, I note what it doesn't say. It's page 217 of the supplemental funding. Starts at page 217 and then it goes over to page 218. In any event, there's another condition of the insurance policy issued to low cost, which is that the insured company must pay and exhaust any applicable excess before insurers are liable. All claims under the policy are subject to an excess, and insurers are under no duty to take over conduct of the defence or any claim on behalf of an insured.
Well, if you go on to the next.
Yes.
paragraph.
Oh, absolutely, Millie. I was intending to read all of it. In relation to this claim, even if indemnity had not been repudiated due to late notification, it is unlikely now low cost would pay the applicable excess as required, with the effect that insurers would not be liable to provide any indemnity. That is not saying we won't touch it. That's just a sort of assertion of a case. That's all that is, we have a policy that we say requires the excess to be paid, if you like, in brackets, meaning money should be transferred over. We think it's unlikely, not impossible, unlikely that the tour operator will pay, and the effect of that would be that we are not liable. It doesn't say, but we're not going to look at your claim, we won't settle it. We absolutely take this point and refuse to go a step further.
Just after they've gone bust, isn't it?
That's all it says. That and no more. That's all I seek to emphasise.
Yeah. But I'd say your big point about this is that, regardless of the technical merits of the defence, if there had been a properly notified legitimate claim in the region of £1.5 million, would these insurers have gone to the wall over saying that they aren't liable for any of that 1.5 million because low cost, who are now in administration, couldn't pay the first 560,000. And you say that even if that was a technically arguable point, it's not one insurers would have wished to expose themselves to at trial, or even if they would, they might have lost. And so you say that at trial there should be an assessment of what the chance would have been of obtaining a substantial payment.
Exactly right, my lord.
Yeah.
The idea
We
that
got that.
the one simply says, we're not going to pay and it's over. If you don't want to pay, this case tracks on and then you have endless other opportunities to settle it. That's what happens in litigation.
Yeah, I think we got the point.
I'm very grateful, my lord. Unless I can assist further, those are the appellant's submissions and reply.
No, thank you very much indeed. Well, thank you to all counsel and those behind for very interesting arguments, very well prepared. We will, of course, reserve our judgments. They will be circulated in draft in the usual way for you to provide us with typological and other corrections, not to re-argue the case. And we'd ask you to also, at that point, let us have any submissions on consequential matters that arise, insofar as you can't agree on order. And if you can just agree on order, then let us have that. We should emphasise that the draft is provided subject to the strict embargo. It's now well understood, and the consequences for breach. And we will then hand down the final judgment and make the order, and those will be circulated electronically now, also in the usual way. Again, thank you very much.